We will begin our webinar in approximately 1 minute. We will begin our webinar in approximately 30 seconds. Hello, my name is Meg Huang. I'm the Executive Director at the Center for Connected Health Policy. Welcome to the National Consortium of Telehealth Resource Centers Telehealth Hack Series, Privacy and Liability. Next slide, please. Please note that the NCTRC will not be sharing your data. We do that for registration. We do collect it for registration purposes, but we will not be sharing it, so it will be kept private. Next slide, please. The National Consortium of Telehealth Resource Centers is made up of the 14 telehealth resource centers who are funded underneath a cooperative agreement with HRSA. There are 12 regional resource centers that cover specific states and 2 national centers that cover policy and technology, respectively. Next slide, please. As some of you are aware, the telehealth hacks began with a series put on by the Assistant Secretary for Prepared Readiness. This series took place over the summer and through September of this year. It transitioned over to the National Consortium of Telehealth Resource Centers beginning in October, and we will continue the series through March of 2021. Next slide, please. A few webinar tips and notes. Note that your phone and your computer microphone has been muted. If you have a question, please use the Q&A function. The chat function should only be used if you are having technical difficulties with Zoom. You can adjust the video sizing in your Zoom using the sliding features. And also, if you require closed captioning, the closed captioning option is down in the toolbar. The webinar is being recorded and will be posted later on the YouTube channel and the website for the National Consortium of Telehealth Resource Centers. Next slide, please. The next couple slides will include the disclosure policy for the University of Arkansas Medical Centers for the CME credits. So we will move through them very quickly, but know that this PowerPoint will also be posted so you can read those later more thoroughly at a later time. Next slide, please. Next slide. Next slide. So if you have not actually sought out CME credits so far for this telehealth hack series underneath the consortium, where you will go is this URL. It's called Learn on Demand, and you will need to create a profile. You only need to create a profile once. So if you have already created a profile to obtain CE credits through this hack series, you will not need to do that again. However, if this is your first time applying for the CE credits, you will need to create this account. Next slide, please. This is the login information for it. You would search for the topic. Today is about privacy and liability, and then you will launch, evaluate, and then click continue to print your certificate. Next slide, please. There is a deadline. All evaluations must be completed by Wednesday, December 2nd. If you do not complete an evaluation, you will not receive the continuing credit hours for this conference. Next slide, please. And this is course evaluation and CE certificates. Again, the deadline is there of December 2nd. And if you have any questions, that is the email and phone number in which you can inquire about further questions. Next slide, please. So today's agenda, we'll be covering privacy and security and tort liability. We will be hearing from Amanda Enyeart first, and then Joseph McMenamin second. Next slide, please. Your moderator and facilitator for today is Dr. Christian Ramers. Dr. Ramers is the Chief of Population Health and Director of Graduate Medical Education for Family Centers of San Diego. It's a large FQHC system surveying nearly 200,000 medically underserved individuals throughout San Diego. He has been facilitating the majority of these hacks. You may be, for those who have attended both the ASPR hacks and the Telehealth Resource Center hacks, may be familiar with Dr. Ramers. He's a wonderful facilitator, and I will now hand it over to him.
Great, thank you so much, May, and good morning to everybody. I hope everyone is safe and healthy in these very unusual times. And as we continue our journey through telehealth together and learn new things, there's two topics that are very, very relevant to all of us that we're going to cover today. And we're very fortunate to have two legal experts with us, Amanda Enyeart and Joe McMenamin, as May mentioned. The way it's going to work is there's going to be two separate talks. Let's go to the next slide, please. And we'll start with this one here. I'm going to introduce Amanda first, and then we'll have 5 minutes for Q&A. Please do use that Q&A box to enter questions that you do want answered, and we will get to as many as we can in the short time that we have, and then we'll turn it over to Joe for the second talk. But let me introduce Amanda Enyeart. Amanda is a partner at McDermott, Will, and Emery, and she focuses her practices on advising clients on digital health issues, including privacy and security of data governance, technology implementation, and telehealth programs. And we're really happy to have her to talk about privacy and security in telehealth. Over to you, Amanda.
Thank you very much for that introduction, and thank you for inviting me to speak today. Today we'll be talking about, or I'll be talking about privacy and security in telehealth. We can go to the next slide, please. I think that probably the easiest way to take a look at privacy and security is to look through the lens of HIPAA. Although, as we'll discuss at the end of the presentation, there are quite a few other federal and state regimes that will also have some influence in how you protect the privacy and security of patient information in telehealth encounters. What I'll do today is to talk about the current state, or talk about the general current state, and also about some discretion that has been introduced with respect to the COVID-19 public health emergency. So I wanted to level set just at the very beginning. I know that many people who are attending today are familiar with HIPAA and the roles that are governed by HIPAA, but I wanted to just level set just to take a few minutes to do that. So HIPAA is the federal law that HIPAA stands for the Health Insurance Portability and Accountability Act of 1996, and it is enforced by the Office for Civil Rights. And the Office for Civil Rights has developed regulations that really are kind of what we really think of as the meat of HIPAA. Next slide, please. So the HIPAA regulations are split into 4 rules. There is the privacy rule, which really looks at the patient's individuals' rights to the data that they have, and also the rights with respect to use and disclosure of protected health information by covered entities and business associates. The security rule is a little bit different. It really is, it looks at the requirements for protecting the security of electronic protected health information only. With telehealth modalities, we are looking generally at electronic protected health information, so it's very, very relevant to the discussion today. The breach notification rule really looks at how to identify when an unauthorized use or disclosure of protected health information actually constitutes a breach that would require notification either to a patient or to a government or to the OCR, or if it's a large enough breach, to the media. And then the HIPAA enforcement rule really establishes the enforcement mechanisms for enforcing HIPAA, including civil monetary penalties and federal criminal penalties for the knowing use and disclosure of protected health information. So next slide, please. So as I noted in the last slide, HIPAA covers basically 2 sets of stakeholders. They're covered entities and business associates. Covered entities are what we probably primarily think of when we think of HIPAA. These are healthcare providers, hospitals, health systems, physicians, also health plans or insurance companies. So any entity that is providing for the payment of healthcare, and then also healthcare clearinghouses, which we don't talk about too much, but these are entities that they process protected health information from non-standard formats to standard formats And they really facilitate the exchange of information, and they're also considered covered entities under HIPAA. The second set of entities that are covered under HIPAA are business associates. And since the HITECH Act, business associates are actually directly liable to compliance with all of the security rule and certain elements of the privacy rule. Business associates are individuals or entities that either create, transmit, maintain, or receive protected health information from or on behalf of a covered entity in order to perform certain functions for the covered entity. And in the telehealth context, business associates will include providers such as telehealth platform providers, and other types of consultants that might be used in telehealth. Next slide, please. So I thought it would be interesting to take a look at one of the very narrow exceptions to the definition of business associate that sometimes comes up in digital health and telehealth, the telehealth context. And this is what we refer to as the conduit exception to business associate. So in the definition of business associate under HIPAA, an entity that provides data transmission services with respect to the protected health information of a covered entity that requires access to that PHI on a routine basis is a business associate. So it's definitional, they'll always be a business associate. But in some circumstances where we're talking only about transmission, where an entity might be moving data from one point to another that contains protected health information, that entity may not actually be a business associate if it does not require actual access to the data, or only has access on a random or infrequent basis, or provides some type of temporary storage. And temporary is very fleeting. In electronic communications, it could be something that's just cached for a very short period of time within the system, but it's not actually really ever accessed or used or apprehended by the entity. In the non-digital world, the mere conduit exception has been applied to couriers generally, post office, FedEx, those types of entities. So you don't have to have a business associate agreement, and those entities are not liable for the security of that information. Under HIPAA, they don't have contractual obligations to covered entities that are developed under HIPAA. In the electronic context, we see this actually applied in some circumstances when we're looking at internet service providers or other types of service providers that are really being a conduit to the information. Sometimes you'll see that argument, people try to make that argument with respect to entities such as cloud providers that actually store data, and that's really not really not possible to do. It's not a good analogy. HIPAA, the OCR has made it clear that an entity that maintains data on behalf of a covered entity, even if they don't have access to getting that data, will be a business associate under HIPAA. And so cloud storage providers, other types of storage providers really are required to enter into the business associate agreement and secure the privacy and security of that data that they're holding on to. Next slide, please. So under the security rule, there are 4 general major requirements. And this, again, we're talking only about electronic protected health information here, but the first and probably least, I don't know, it's very important in the enforcement actions that we see from OCR. We see that this is an element that is often either not done or not done right, but this is a risk assessment that really looks at the potential risks and vulnerabilities to all of the confidentiality, integrity, and availability of electronic protected health information in a system. And I've set out what those mean. I think a lot of times we think of security and we're just thinking about the confidentiality, making sure that nobody can get to that data, but availability and integrity are also important components to the security role requirements. The second requirement is to protect against anticipated threats and hazards to the security of that protected health information. And then also to protect against the anticipated uses or disclosures of electronic protected health information that are not permitted by the privacy rule. So here we see how the privacy rule and the security rule kind of work together. And then finally, an entity that's either a business associate or covered entity that's covered by the security rule needs to ensure that its workforce complies with the security rule. And there are standards for each of these elements within the security rules, things like training, requirements around auditing and access and all sorts of requirements. But these are just kind of the threshold main elements of the security rule. Next slide, please. So within the telehealth context, one aspect that's very important are the vendor relationships. And so here I'm making an assumption that most of our attendees are healthcare providers or coming from that world and not from the technology world or technology provider world. And I know that might not be the case, but we'll just look at it through that lens. So vendor relationships are very important for telehealth, particularly with respect to your telehealth platform vendors. And the thing to keep in mind here is that even if those vendors are subject to HIPAA as business associates, subject to the security rule, the covered entity really has the obligation to make sure that it's entrusting its protected health information to vendors who have the ability to comply. And so we often counsel our clients to do some diligence on vendors before they enter into an arrangement with a technology vendor to make sure that that vendor is actually capable of achieving HIPAA compliance. This could be through things such as asking for evidence of the security risk assessment, if not the results or the summary of the risk assessment. And other types of due diligence that you might think of to vet a vendor. And then the other side of the selecting a vendor is looking at whether it would be possible to negotiate certain types of liability provisions in the agreement or in the business associate agreement, typically in the services agreement, and how to manage the breach disclosure process. Those are probably the primary things that we take a look at for our clients, among a lot of other business terms within a service provider agreement. But one of the things that you'll see is that vendors typically try to limit their liability. They put a cap on the damages that they might be subject to under a service provision agreement. Usually it's tied to the amount of fees that are paid in a year or a multiple of a year period. And what we try to do is see that liability for breaches of security of protected health information are carved out of that limitation of liability, or at least subject to a higher threshold, because breaches can be quite expensive to remediate, and it may not be, an entity might be surprised if they've entered into an agreement that has a cap on damages that really won't cover their costs if their business associate breaches the protected health information that they're holding. Next slide, please. So I thought it might be helpful just to show some of the best practices with respect to using telehealth technology and setting it up. Some of these might seem very simple. There are, of course, other requirements, but these are the things that we're looking at specifically when we're looking at telehealth, is just making sure that staff and anyone who has access are using strong passwords, both for the EHR and the telehealth platform access, using only secure methods of communication when sending patient data or communicating with a patient. When logging on to a telehealth platform, making sure that the telehealth, the network is secure, the Wi-Fi is secure. Something that people might not think about always, but it is helpful, especially in this work from home environment that we have, is just making sure that you're in a private location during the telehealth encounter, thinking about what's happening around you and whether other people might be able to hear or have access to what's going on in your communication. Reminding that for new patients who haven't been seen in person already, that a notice of privacy practices is still required, and compliance with the notice of privacy practices is required. And just to back up a little bit, a notice of privacy practices is the form that you get when you go see a doctor. Probably everybody has seen them, where you sign an acknowledgement that you've received a list of the practices that the healthcare provider agrees to with respect to the uses and disclosures of protected health information, and also patients' rights. And then also requirements to maintain and secure records securely for the telemedicine encounter. Usually some states require certain requirements with respect to record keeping for telehealth. Generally, they follow along the same lines as record keeping requirements for in-person healthcare. Next slide, please. Just a little note about HIPAA compliant modalities. Sometimes you'll see vendors that claim to be HIPAA compliant, or not the vendors, but they claim that their product is HIPAA compliant. And it's just something to remember, that HIPAA compliance is really more than just the technical safeguarding of the information, from a technical perspective. There are administrative and also physical requirements under the security rules. So an entity can be HIPAA compliant, but their product is not necessarily HIPAA compliant, because there's so much more that goes into HIPAA compliance than just the technology. But the modalities, as I said, can be compliant. And the things that we look for HIPAA compliance, again, as I spoke with due diligence, is things like password protection always, whether the information is encrypted, whether there are authentication techniques that are used, or what those authentication techniques are used. That all kind of gives you an insight into the type of security that's being used in the technology. Next slide, please. So in the pre-COVID world, we often warn against using what are considered common technologies to conduct telehealth or virtual health encounters. And these would be technologies such as text and email that aren't set up in a secure way. Also certain video technologies, FaceTime, and those types of communications that you might be perfectly happy with using one-to-one, in your personal life, but are not necessarily HIPAA compliant. They may not have a business associate agreement tied to them. But if we go to the next slide, we'll see that OCR has announced discretion. We're calling it the OCR waiver, but it is really a discretion not to impose penalties for HIPAA violations during the public health emergencies for a certain segment of the activities of a certain segment of covered entities. And so this applies just to providers who are using telehealth technology to provide healthcare or education activities with their patients. So this enforcement discretion does not apply to payers, and it doesn't apply to other types of services that providers are providing outside of telehealth technologies. But what the OCR has said is that it will not impose penalties for violations of HIPAA, and this applies both to the privacy rule, security rule, and the breach notification rule. So there is a little bit of flexibility here to allow telehealth providers to use technologies, or to use providers who may not have engaged in telehealth communications before the public health emergency, to use common technologies in order to reach patients to provide the care that's needed. And the OCR waiver applies only to HIPAA data, but there is similar guidance that SAMHSA has put out with respect to mental health or behavioral health data under 42 CFR Part 2 as well. Next slide, please. So the enforcement discretion here, this slide just lists what OCR identified as the types of non-public facing platforms that are subject to the enforcement discretion. And so the list that I provide, the Apple FaceTime through iMessage, those are all technologies where there are certain safeguards that are imposed. It's more of a one-to-one communication, and so that there is less chance of interception. On the next bullet, the public-facing platforms like TikTok, Facebook Live, Twitch, those are not included in the discretion. So there is some qualitative difference with what is permissible to use under the enforcement discretion. And then just as a note, OCR did recommend that providers who actually want to have a higher level of privacy and security do actually seek out HIPAA compliant entities who will sign a business associate agreement. And that's the advice that we have been giving clients as well. Particularly clients who are foreseeing that they might be using telehealth technologies after the end of the public health emergency. The OCR discretion lasts until they declare that it is no longer in effect, probably through the public health emergency, but we don't know when it will end, and we're trying to encourage our clients to make sure that they are using technologies that they can use going forward after the discretion is over. Next slide. This is my final slide, and it's just a reminder that there are all sorts of other governmental regulatory regimes that actually apply, that touch on privacy and security, but do apply to telehealth. So I've added this list just as information. We won't be going into any of the particulars here, but I think that's about it for my time. So I think we're open for questions for a few minutes.
Great, thank you, Amanda. That was perfect timing. We have had some questions come in, quite a few, but we've got about 4 minutes to go through them. So let's try to get to these. The first comes from June Strickland, who I'm presuming is a behavioral health provider. And June says that given that many, if not all platforms say that they're HIPAA compliant, how can practitioners know for certain? Where's the due diligence? Is it on the burden of the covered entity or the business associate?
So it's a mix of burden. So from a contractual perspective, if a business associate says that they can do certain things and they can't, then there is definitely liability that on the part of the business associate. But really, from a HIPAA perspective, it's best for a provider to be confident that their technology vendors are compliant, and things that can be done to gauge that are to get reports, ask for policies and procedures, ask for the risk assessment, or at least a summary of the risk assessment. Certain providers have voluntarily engaged in high trust or other types of certifications, which aren't necessarily HIPAA compliant certifications, but could indicate that they have implemented the kinds of practices that are required under HIPAA.
Great, thank you. We have a pair of questions about the phrase mere conduit, which I think was in your slide. The first comes from Barbara Kabutzi, who says, would you consider an eFax provider to follow under that exception as a mere conduit? So
an eFax provider, I believe that is true. I know that there is, and I would have to look it up. I know that there, I'm not absolutely sure that the eFax information is electronic health, public health, or electronic protected health information, but that type of vendor could be. But if they are servicing the eFax, whatever, if they have access to those files, then probably not. So I would have to actually know how the technology is working in order to make that determination.
Okay, a similar question from David Resnikoff regarding other telecommunications such as telephone, voice over IP, and cell phones. Are those considered mere conduit as you defined it?
So they generally, yes, they are not subject to HIPAA as business associates.
Okay, great. Another question from Andrea DeLange about email. I think you mentioned this in your slide, but just to reinforce, do we have to be using encrypted email in order to be HIPAA compliant?
So that's a little complex. So encryption is not required under the security rule, but it is something that's called addressable. And so an entity needs to make a determination about it, whether it's reasonable for them to use technologies that are not encrypted. It's kind of hard to get to that place these days, saying that it is reasonable to use unencrypted email. However, if the only way to get, or if one of the ways to get information to an individual that an individual has requested is through unencrypted email, and the entity lets the individual know that that method is not necessarily secure, and the individual says, send it to me anyway, then you could go ahead and send it without being subject to enforcement if there happens to be a breach of that information in that transmittal.
So I'd like to fit in just two more quick questions. You mentioned the notice of privacy practices, which is important to give patients. Do you think that covered entities need to revise their notice of privacy practices now that we're in kind of a new reality?
So the notice of privacy practices itself probably does not go into the detail of mentioning these types of this reality of potential enforcement discretion. That's not to say some entities also have privacy practices that are or privacy policies on their websites. And that would be a different consideration, but those are usually not bound. Those are usually not providing just the HIPAA requirements. Those are more akin to what the technology provider is letting people know. So we'd have to take a look at each of those and determine, but I think probably not for the notice of privacy practices right now.
Okay, great. And the last question, I might have said I only had two, but here's another one. Helen Laboon writes that most providers are very familiar with HIPAA. We've been living and breathing HIPAA, but the HITECH Act, people are much less familiar with that. So what do providers need to know about the HITECH Act?
So the HITECH Act, it's interesting that you say that because it's been in place for quite some time now, I think. And so I don't even, in my mind, I don't even really distinguish HITECH Act anymore because I just think of it all as HIPAA. But I will say that the features of the HITECH Act that change things are direct liability for business associates for compliance with the security rule. So that's quite important and a big shift for business associates. And that's the primary. There were definitely some changes that were mandated to be made in notices of privacy practices. There were business associate agreement changes that needed to be made as well. Some changes to marketing and the sale of protected health information, but everything has now been kind of incorporated into the regulations through the Omnibus Final Rule in 2013. And so I think what we see now in the regulations is a unified HIPAA rather than split out.
Okay, excellent. Thank you so much. That was very, very helpful. And thanks for taking those questions as well. We're going to move on to the second half of our presentation, and it's my pleasure to introduce Joe McMenamin. He is one of those rare gems that has a JD MD after his name. Nice to have on your side giving advice. He's a physician attorney and the principal at McMenamin Law Offices, PLLC, a healthcare boutique concentrating on the law of digital health. Joe advises institutional and professional telehealth service providers, academic medical centers, remote monitoring services, and other clients on a broad array of medico-legal questions arising from distance care, and more recently from the application of augmented intelligence to healthcare in general and to telemedicine in particular. He's also the general counsel to the Virginia Telehealth Network, and we're very pleased to have him with us. Joe, over to you.
Thank you, Dr. Ramers, and thanks to NCTRC for the opportunity. Next slide, please. I will go over this very briefly. It's a set of disclaimers. The only one I'll mention is that I'm speaking now today only on my own behalf and not that of anyone else, specifically the TRCs. Next slide, please. This talk is dedicated to a discussion of malpractice in the context of telehealth. And the formatting seems a little odd. I don't know what happened here, but the idea that I had in creating this slide was to provide a little bit of taxonomy for the sake of organization. I find it, when I'm trying to learn new material, I find it easier when it's better organized than when it's not. We can distinguish for purposes of this presentation between civil law and criminal law. Nothing I will talk about today has to do with the law of crimes. And then if we focus on civil law, we can divide that between tort and contract. Torts arise without the necessity of any sort of agreement between the parties involved. Contracts exist only because the parties to the agreement have in fact pledged to do various things for each other and in exchange for what the other party is doing. We divide torts into intentional versus unintentional. If I deliberately slug you in the mouth, that is an intentional tort. If, on the other hand, I'm careless in the way I drive my car, I'm not intending to hurt anybody, but I nevertheless hurt you because you're crossing the intersection as you have a right to do. That's an unintentional tort. Malpractice is a species of the broader tort of negligence, which is an example of an unintentional tort. It has 4 elements, and nothing about this is remotely revolutionary. I'd be disappointed in any first-year law student who couldn't rattle these off. Duty, breach, causation, damages. The plaintiff, the person bringing the suit, usually the patient or a spokesperson for the patient, has to prove each of these elements or loses the case. That's what we refer to as the burden of proof. If we imagine a case in which the evidence is absolutely even Steven, there's no difference between the two, they're equally heavy, equally weighty, the plaintiff loses, the defendant wins. Next slide, please. The test of the care that any provider offers to any patients is referred to as the standard of care. It's important to understand that the standard of care does not mean that you need to, if you're a provider, you need to live up to whatever is being done today at Stanford. It means you have to act as a reasonable person in similar circumstances would do. Typically, the group to whom you are compared are practitioners of your discipline or your specialty within a relevant geographic area. That relevant geographic area in some states is the entire United States. In some states, such as mine, it's the state itself, and in a few, it is a locality such as yours or one similar to it within the state. The test then that is applied is the test of the relevant standard, and you have to know what geography applies, which means you have to know the relevant state law. Also, the standard refers to what skill and diligence is exercised by practitioners in your field under the same or similar circumstances. That's especially pertinent today in the setting of a pandemic. As we'll see in a subsequent slide, there's a lot of thought given to the proposition that it is unreasonable to ask a provider to live up to the same standard of care under these very difficult and very trying times that we have today, given all sorts of problems such as shortage of PPE and so forth. And therefore, one must consider the circumstances under which a given episode of care is provided in order to form a fair judgment about whether that care was standard and therefore lawful or not. Also, the time at which the case arose is important. Technology changes, medicine changes all the time. If tomorrow morning some brilliant scientist somewhere comes up with something that revolutionizes the management of congestive heart failure, it may well be that in due course it'll become the standard of care to adopt the new technology. But until it does, you cannot be criticized, at least not legitimately, you cannot be found liable for not following that brand new practice that some scientists just came up with. How is a lay jury supposed to figure out what the standard of care is for working up abdominal pain or anything else? The answer is we bring in experts. These are persons with knowledge, skill, training, and experience that in the judgment of the court, and it is for the court to make this determination, are able to help the jury, to assist the jury in understanding what the standard is and whether it was met or whether it was not in a given case. Whether a person qualifies as an expert is sometimes a topic of great debate in the course of a trial. In general, in telemedicine, in every single state that I know of but one, in every single state that has addressed the topic, and not all states have, the standard of care is the same as that which prevails in person, notwithstanding that with distance care, of course, you cannot do the kind of complete physical examination that's possible to do in person. The only exception I know of, and if anyone else knows of any others, I'd be delighted to learn, is in Hawaii, which interestingly, holds telehealth providers to the standard that one might anticipate or impose upon those who are providing consults by telephone. So if Dr. A is covering for Dr. B, and Dr. A takes a call from the patient by phone, then, to my understanding of Hawaii's law, if the telehealth provider offers care of comparable quality, then that is complied with the standard in Hawaii. Can't rely on that in any of the other 49 states, to my knowledge. Next slide, please. I will not dwell on this. This could easily be a sermon unto itself. The received wisdom among many, including a great many of my peers whom I respect highly, is that if we adopt and follow clinical practice guidelines, best practices, and so forth, we will do, not only will we improve the quality of care, but we will also improve our legal liability exposure. We will diminish the likelihood that someone will successfully bring a claim against us. I am a contrarian and I disagree. For a whole host of reasons, I do not think we should hang our hats on clinical practice guidelines. I'd be happy to elaborate on that in the Q&A if there's time and anyone is interested. But I find that more often than not, and there are empirical data that demonstrate this, these guidelines are used more often against providers than they are used in their defense. Next slide, please. So don't trust them, in my opinion. Informed consent, volumes and volumes have been printed and written about this, and I'm not going to try to do a comprehensive study of the topic in these few minutes. Basically, though, there are three ways by which the consent a patient grants is judged. In those states that apply an objective standard, the provider is expected to disclose what a reasonable provider in similar circumstances would reveal. In those states that have adopted a subjective standard, the test is not what the reasonable provider would reveal, but rather what would a reasonable patient want to know. And then in at least one state, the standard is what this particular patient says that he or she wanted to know at the time. Likewise, with causation. Remember I mentioned that negligence and malpractice has duty, breach, causation, damages. Causation is the question, is the so what question. If you walk into my office, I'm a general internist, you give me a wonderful history for lung cancer and I don't detect it, in spite of the fact that your history is perfect, the physical findings are consistent and the chest x-ray shows a mass, but on leaving my office, you walk across the street and you're hit by a bus and you die on the spot, you do not have a case against me for malpractice because you can't prove causation. I didn't kill you, the bus killed you. In my hypothetical. Therefore, my failure to make the diagnosis doesn't matter from the standpoint of liability. Okay, so with informed consent, the question once again is, so what? We reveal this information, not that information, the patient's complaining about it. Under the objective standard, we look at what a reasonable patient, informed of the allegedly omitted information, would have decided. Would he have proceeded with the procedure or not? Under the subjective standard, which applies in some states, the question is not what a reasonable person would do, but rather what would this particular person do had he, she been told about the allegedly omitted information. In distance care, we do not have much clarity on these things. Typically, these are decided in common law, in the courts, and there have been remarkably few reported cases for us to go to school on. That's wonderful for the providers and for those who write their insurance, but it's not good for the student of the subject. We'll get to that in a bit. Next slide, please. One thing I will mention with respect to telemedicine is many states do specifically and expressly require that you document consent. It's generally a good idea to do that anyway, but certainly in those states where it's required, you want to make sure you do that. This is a list of possible theories of liability that could be brought in a few instances have been brought against healthcare professionals. The commonest claims arise in teleradiology, probably for the simple reason that radiology utilizes distance care technologies probably more heavily than any other specialty. Informed consent is a popular theory to the extent we can talk about a popular theory in a type of litigation that we've seen very little of. And the suggestion there is whatever you do, don't oversell, don't exaggerate the benefits of telemedicine or unfairly diminish the risks. Diagnostic failures. This is particularly relevant in direct-to-consumer settings where it's often very hard for the doctor to get access to the old chart. It may be hard for him to get vital signs. Lab data and diagnostic images, for obvious reasons, are often hard to come by. Next slide, please. And so as a result, it's challenging to make a diagnosis. That's a popular theory of liability, even in in-person care. It certainly would be, therefore, in a form of care in which the diagnostic armamentarium, if I can call it that, is more constrained than it is with in-person care. Other possible theories: continuity of care. One of the problems, again, with direct-to-consumer, and I'm not at all averse to the concept, is that it may be difficult to get the record of that visit into the patient's EHR. For example, there have been papers criticizing antimicrobial stewardship among people who provide distance care. The allegation is that we are too liberal with our use of antibiotics. There have been papers demonstrating, or purporting to demonstrate at least, that the accuracy of dermatologic diagnoses by non-dermatologists relying upon transmitted images is poor and substandard. As one who is a matter of religious principle never admits that there's ever a breach of the standard of care, I of course do not admit that, but there are people who have put that in the published literature. Software or power failures are certainly possible. Next slide, please. A theory that I predict we will see, and maybe see very soon, is that a plaintiff somewhere is going to allege that the failure to provide telemedicine or the access to telemedicine was itself a breach of the standard of care. I think that theory will be asserted. Now, in a lot of states, legislatures have enacted laws intended to diminish the liability exposure of healthcare professionals. And in many states, that's been of great value to the providers in terms of getting insurance and getting it more cheaply than they could otherwise. The Institute of Medicine has published something it refers to as crisis standards of care. And it argues this was not for tort reform purposes, but just because they thought this was logically correct and fair to physicians and other health providers, that when we have a crisis, such as the pandemic, this notion of the standard of care needs to have within it sufficient flexibility to reflect the fact that we are operating today under very, very difficult circumstances that do not apply 99% of the time, thanks be to God. I listed here a handful of states, by no means exhaustive. These are examples of states that in the face of the pandemic have enacted legislation, or in many instances, the governors have signed executive orders providing some degree or other of protection from liability, not only for healthcare professionals, but for other sorts of professionals and indeed businesses. The particulars vary state to state. It's not necessary to get into detail with respect to each state here, and it wouldn't be feasible anyway. These are just a few examples, but if you're practicing in one of these states, then it may be worth your while to learn what may be available by way of either tort reform or some pandemic-specific enactment that will help diminish your liability exposure. Next slide, please. Now, the generally received wisdom with respect to telehealth is that the care is provided at the location not of the provider, but of the patient. From a lawyer's point of view, the reason that matters is because, well, a couple of reasons. One is it means that the law of the patient state, not the law of the provider state, will control the case. It also means that the jurisdiction, that is, what court is deemed by the law to have the authority to decide the dispute, will be that of the patient state, not that of the provider state. Why does it matter? Well, we'll see that, I think, in the next slide. But part of it is that if you could please advance it, the jury will be different from location to location. The bench will be different. In my home state of Virginia, I live in Richmond. It's much better for a defendant to be tried in Henrico County, just south of the city of Richmond, than it is in the city of Richmond itself, even though those courthouses are not 20 miles away from each other. But the veneer, the group from whom the jury will be pulled, is a very different group in Chesterfield County than it is in the city of Richmond. I could multiply examples, but this is an example of why the jurisdiction may matter. It may also matter because, remember I mentioned that the standard of care might be national, it might be state-based, or it might be based on the locality. Why do we care? Not so much because the workup of abdominal pain, to use my earlier example, varies between Chicago and New York, but rather because the pool of experts from whom the plaintiff gets to pick is broader if the standard is national than if it is local. Because after all, for the judge to determine that Dr. X really is an expert, the court has to make the determination that Dr. X really knows the relevant standard of care. And if the standard of care is national, X has a much easier time convincing the court that he knows what he needs to know than if it's the standard within Galax, Virginia, as opposed to, Richmond, Virginia. Defenses also matter. Defenses could easily, again, be a subject for a whole different seminar, but an example is the statute of limitations. In most states, including my own, the statute is 2 years, meaning that if today I were your doctor and I made a mistake and I caused you harm and you claimed I breached the standard of care, you would have 2 years from today to bring that claim. So you would have until what? November the 18th, 2022. And on November 19th, 2022, no matter what the facts are, you are out of court. You have lost because it is too late to sue. Well, there are some states where the statute of limitations is only 1 year. That's very nice from the defendant's point of view. There are others where the statute may be 3 or 4 years. That matters, or at least it may matter, depending upon what the facts are. Also, tort reform. Some states, for example, have caps on damages. You cannot recover more than X number of dollars, no matter what the facts might be in these states. Other states don't have that. So whether the case is tried in Virginia or in Wyoming or in Illinois or in California may matter a great deal for a whole host of reasons. Next slide, please. So in choosing where you wish to offer your services, think about the malpractice climate in each of those states, because that may very well be the climate that you will be living under in the event of a claim. I indicated earlier there have been very few reported cases. I think there's a bunch of reasons for that. One is that, at least by legal standards, telemedicine, even though it's been around for decades, is comparatively recent development, and it's been, until recently, been utilized on only a very small scale. Besides, we have to recognize that many cases are never reported, and of those that are, many are closed subject to confidentiality agreements, which means the parties are not at liberty to disclose what the terms were, which may be good for the parties, but once again is tough for the student of the subject who'd like to learn what a given case is likely to entail by way of financial risk. And then I would like to think, as an advocate for providers, that a very, very good reason, and a very big reason why we don't have more cases, because the care is of good quality. Next slide, please. Of the very few reported cases that have dealt with this, telemedicine has often been just a side issue, a matter of fact, but not of great relevance to the legal issues that really determine the case. This slide is titled Pseudo Malpractice Cases because I distinguish between the two types of cases mentioned here and genuine medical malpractice cases. Telehealth is often used for the management of patients who are in the prison system for a host of very good reasons. When such a prisoner claims that there's been malpractice against him, what he generally has to prove is set up by a federal statute that is really not a malpractice law at all, but rather a civil rights statute. And that prisoner has to prove, and this is a direct quotation out of the law, deliberate indifference to a serious medical need. That is a very heavy burden to carry, far more onerous than showing a breach of the standard of care. Most of the time those cases fail, particularly because the plaintiffs, that is the persons bringing the suit, are generally pro se litigants. They do not have lawyers, they are representing themselves. There's also a whole set of cases, and there are plenty of these you can read about, that involve internet pharmacies, where in exchange for my Visa number, a pharmacy someplace in cyberspace will be happy to send me all the Viagra or Oxycontin or whatever it is that I want. And there have been lots of cases that have held that that's not proper. I don't think it's necessary to dwell on them because in my mind, that is not a telemedicine case, that's a different animal. Next slide, please. But just be aware that they're out there. I think that in spite of this good record, things may change. For one thing, we're in the United States, it's 2020, it'll soon be 2021. In the US, we sue our mothers from time to time. Sometimes we win. I think we will seek more claims in the future. Partly because we're using telemedicine far more heavily than ever before. Partly because those who are advocates for this form of care, and I consider myself one, have a tendency to push the envelope. I don't mean that in a critical sense. The way to learn that a particular technology works or doesn't work is to try it in a given circumstance and see what happens. But that obviously entails legal risk. There's also privacy risk. Remember, and I think we really owe a debt of gratitude for Amanda for organizing a great deal of information very succinctly and neatly in her discussion. But in addition to all the federal authorities, as she pointed out in one of her last slides, there are lots of state laws as well, every one of which remains good law today. And unlike HIPAA, under which there is no private right of action, many of those state privacy laws do permit a private right of action. So you could be sued for breaching the patient's privacy, even though you have complied with HIPAA very nicely. Next slide, please. There's also, of course, always the ever-present risk of a snafu with the technology. I won't spend long on this next slide, just to point out, however, that the plaintiff's bar is very much aware of telemedicine and it is aware of COVID. I have no knowledge whatsoever of the Hollander law firm. I'm not advocating for them, nor am I criticizing them. I'm just pointing out that among many others, they are advertising for cases and trying to persuade folks to contact them if they think they've been malpracticed upon or because they've had some sort of mishap with respect to the care of a COVID case. Why do I mention it? Because ads work. The plaintiff's lawyers wouldn't pay for them if they didn't. This drives traffic. It will lead to litigation. Next slide, please. And by the way, not only is this considered perfectly ethical, it is protected by no less an authority than the Constitution of the United States. You have a constitutional right to advertise. It's been established at the highest court in the land, so it's here to stay. A word about insurance. In the early years, when I first getting into this, it was often very hard to find protection. Now that's no longer true. Matter of fact, not only can you get it, but very often your existing policy may cover it automatically, or you can get a rider or some other portion, some other agreement, side agreement, that will extend the coverage, often at very little cost or even no additional cost in your premium. Now, on the other hand, the typical malpractice policy does not of itself provide so-called cyber risk coverage, nor does it provide protection against some failure of the equipment. Now, these policies vary a great deal, much like laws from state to state, so you need to know what your policy says. A good quality broker or agent should be able to give you a lot of information about that, but don't assume that all of your risks are taken care of just because you have a malpractice policy. You may or may not, but you may need additional coverage. Usually, the coverage of any policy is limited to those states where the practitioner is licensed. So if you are tempted to offer services where you are not, there's a lot of reasons why that's not a good idea, but one of them is that you'll probably not be insured. Next slide, please. These are, I think, these are just a few points on risk management. I'd like to think they're reasonably self-explanatory, and we're running low on time, so I won't go down them. But there are ways to diminish your risk. This is my attempt to offer a few of them for your consideration. I would point to the website Manner. That is a real phenomenon. To my great amazement and frankly chagrin, I actually had to instruct a physician, a very highly educated, very highly trained professional, that no, he really shouldn't smoke when he's conducting a telehealth visit with a patient by video. I was surprised it was necessary to say that, but indeed it truly was. I'll stop there so that there's some time for questions. Thanks very much.
Thanks, Joe. That was outstanding. I think we do have a couple of questions, and I'll start with one of my own, which was, as a clinician, I'm really just curious. I'm comforted to hear that there have not been very many cases, actually. So thankfully, people are more concerned about dealing with the crisis itself. But in one of your slides, you mentioned that in at least the last 5 years or so, 66% of telemedicine-related claims were related to diagnosis or a misdiagnosis. And you also mentioned that there were some settlements related to confidentiality itself. So in the small number of cases that we are seeing related to telemedicine, what types of cases are patients bringing against providers?
Well, I tried to address that with a slide that talked about the fact teleradiology is a relatively popular field, either a failure to diagnose or a failure to diagnose timely. The request is that the image be interpreted stat, and it isn't. It's interpreted at the regular pace. Others where failure to diagnose, and again, I can't prove this, but I think it's because very often with telehealth, of course, you're limited to what you can do diagnostically. And then there have been a smattering of other cases of various kinds. But I would say that there have been so few that we don't come remotely close to anything like what I would consider a scientific or representative sampling to be able to generalize. I think that'll change, but for now, most of these, frankly, have been one-offs. There's not been a big pattern. There's not been a lot of activity so far.
Great. And another question from Elisa Stevens about, you had referenced that standard of care is a very important foundational principle here. And Elisa, it seems like, is writing from Arizona, where there are psychiatrists and mental health nurse practitioners using different types of technology, some on telephone and some on video conferencing. Is there any decision about which is the proper standard of care?
The short answer is no. In all cases, the test is reasonableness. So if reasonable psychiatrists or psychiatrically oriented nurse practitioners in Arizona are caring for patients by phone as opposed to audio video, and assuming there isn't any state or other authority saying that's prohibited, then your doing so should, by definition, comply with the standard of care. If, on the other hand, reasonable nurse practitioners and or psychiatrists in Arizona are not doing that, and you are, and if some harm results as a consequence, then you may face some exposure there. So the yardstick is, what is everybody else doing? And if most people are doing X and you're doing X, then even if the outcome is bad, you should be in good shape. If everybody's doing X and you're doing Y and nobody else is doing Y and something goes bad, then that's a problem.
Keep coming back to the image of walking into a dark room and just feeling our way around together. It seems to be apropos. One final question from Wendy Matos. You discussed liability insurance a little bit, but her question is, are the insurance companies requiring additional coverage for providers offering either telemedicine or using remote patient monitoring devices? Different insurance than they already have.
Are the carriers requiring it?
That's the
No.
question.
No, they'll be happy to sell it to you. but I very much doubt that a carrier would deem itself to be in a position to decree to a potential purchaser, i.e. the doctor or the provider, thou shalt purchase such and such. Now, for the provider's own good and that of his, her institution or organization, it would be prudent, generally speaking, to have coverage. I've had to try cases occasionally where the doctor was uninsured. It is not a pretty picture. I suppose it could be that a carrier might refuse to sell you coverage A unless you also buy coverage B. I can imagine that. But I don't think that the law would give a carrier the right to say to a doctor or nurse, thou shalt purchase such and such. They offer it, you can purchase it. Your own organization may require you to do it, but not the insurance company.
Great, and maybe time for one last question about jurisdiction. So it's from Juan Pacheco, who asked, can a provider request a patient to agree to a jurisdictional change to his or her jurisdiction of practice in the case of any possible complaint?
You can ask, but your chances of getting a judge to enforce it are not good.
Okay.
Generally speaking, there are some exceptions to this, but you cannot really contract your way around jurisdiction. Now, there are contracts where particularly organizations are dealing with each other, and the parties agree that in the event of a dispute, the matter will be heard in Cleveland or whatever, and you can do that. But with respect to, I would think, especially if you're dealing with an individual patient, it would probably be viewed by a court as unenforceable that the doc or the hospital, the health system, whoever it is, says we're going to try this case at such and such a location. I doubt that a judge would be willing to enforce that.
Great. Thank you so much, Joe and Amanda, for sharing your expertise. Incredibly valuable information. I'm going to turn it back to May because we're just about at the top of the hour.
Okay, thank you to our wonderful speakers, Joe and Amanda, and thank you to Dr. Ramers for your wonderful facilitation. Just to let you know, we do have for December an upcoming webinar series that will be focusing on college health. We are doing that in association with the American College Health Association. December 7th, the topic will be building lasting telehealth programs on college campuses, and we are still working on the December 10th webinar topic, but it looks like it will be on mental health. So please stand by and look at the Telehealth Resource Center's website for further information. Again, you have until December 2nd to fill out your evaluation if you are interested in getting CE credits. Remember, you need to go to the Learn on Demand website, that is learnondemand.org. Once again, thank you to our speakers. Thank you to Dr. Ramers for your moderation and facilitation. And thank you everyone for showing up today and attending this webinar. Have a great day.